All right, guys. Good morning, everybody. How are you this morning? I am Nancy Lane, and I have been a member of this board and professional standards risk management. Well, Jen's on the call, so she can verify the beginning of time, or was it right before the beginning of time? Pretty sure it was close, right in the same. Um, and through that, and as a broker and broker record, and um, just working on both the local and state professional standards, in fact, the biggest cause of lawsuits is lack of disclosure. And so we're going to focus a little bit on that today. We're going to talk about the RPA and how preparation helps to keep you out of trouble on the backside of that transaction, and how you stay ahead of problems rather than chase them. One of the things as a broker I can tell you is it's not fun to get that phone call. Oh, I screwed up. Can we fix it? And sometimes yes, sometimes no. But the best way to stay out of trouble is to prepare for it and to not let it basically run you. So what we need to do is make sure that the information that we have, there we go, and you stay up on the newest information possible. So CAR has a very helpful section of their website that will give you basically the information as it happens, or as they are updated that it happens. And you can see here in this section, legal Q&As, new laws and disclosure charts. So we've got 2026, 25, 24, all the way down to 22, all of the new laws that have come into play that are specific to real estate. There are obviously laws that didn't involve real estate. And this will give you a helpful section on how to interpret those and how to stay ahead of the problems that they present. So this section not only has that information about laws, it has disclosure charts, it has new homes, leases, our regular RPA, sales, this sales disclosure chart, and I'm going to give you a copy, or I'm going to show you a copy of it in a minute, has probably the most thorough information on what triggers a disclosure. There are so many things that as agents we run through in a transaction that we aren't necessarily aware requires us to make an action or to ask for disclosure. Specifically trusts, for example, a lot of people aren't aware that although the trusts are exempt from disclosure in the regular sense, they don't do the TDS and SBQ, there's another form that a trust holder should fill out that will give any information that they have available to them. And then, of course, there's the summary of the disclosure chart. And then it has a plethora of forms in here or pages in here that will give you advice on how to stay ahead of rules and regulations, advertising, what's required in an advertisement. A lot of people don't understand, for example, in the advent of social media, that every potentially first contact on that social media. So an ad or something where you mention that you're a realtor, you're holding the sign with the sold, etc. That requires you to have your information, your broker information, and your DRE number on it readily available, either in your caption, in the photo, or with one click. So again, a lot of people aren't aware of the requirements for advertising, etc. So that's just one. And you can see there's just so many that are available in this section here. This section is actually, I think it's 17 pages, and I'm not going to go through all of them, but it has a ton of information that, well, you would be well served to put this in your bookmarks and have this available to pull up anytime you have a question. And it's crazy helpful to have that available. The summary chart that I mentioned is the applicability of state and federal laws. So again, you'll get an agent on the other side that says, oh, it's required to do X, Y, or Z. this is super helpful to pull this up and say, okay, no, it's not, or here is the required information. And this will have in it a lot of clicks that you can go through to the sales disclosure checklist, the charts, leases and rentals, new home disclosure charts. That's one that a lot of people are not aware is a requirement. So we think a lot of times, we used to think, you would just go into a new home sales office and give them your information, your people bought the house, and then you got to check. Some of that information is required to have a disclosure. If your name is on it, you're getting paid for that transaction, even as a referral, your agent is going to, or your client is going to consider you his or her agent, and you still have some responsibilities as the agent for that person. Then there's an REO disclosure chart, et cetera, et cetera. One of the questions I had the other day was a condominium or other common interest development disclosures. There are a number, especially in Carlsbad, of developments. My brother actually owned one at one time, a completely standalone house, looked like every other house you've ever seen in your life, but it was a condo because the land that it sits on was held in combination with probably 30 other properties. Because it was never subdivided. I think when they were building it, there was just such a rush to build that they never did the subdivision. There is also some areas, for example, along the coastline that have manufactured homes, and same situation. It's a manufactured home, but it's listed on the title report as a condominium because of the way it holds the title to the land. So again, you have to be aware of the nuances and the differences in these types of things so that when your client asks you a question, you have the correct information, or you can point them in the direction of the correct information. The new home chart I mentioned is very specific to new homes, obviously, but it gives you the scenarios for each of the situations. Now, this is supposed to pull up. Hold on one second. It's having an issue talking to me. Yeah, it won't pull. You can search this table this way, but basically what it does is it goes through every scenario in the new home purchase and each section and whether or not it triggers a disclosure requirement. So this is the one that I was telling you is super handy to have. And you might want to just kind of bookmark this on your computer so you can pull it up when you have a transaction, because what it does is it goes into the specifics of each section of the form. When you get into an escrow situation, I mentioned briefly, for example, if you have an exempt seller, trust or something, LLC, stuff like that. There's an ESD and a WHS or a WHSD, which is the water heater smoke detector. You still have to do certain disclosures specific to even a trust. So again, to have that knowledge, part of what our new world in real estate is that we're being questioned for the value that we present for the compensation that we ask. So having the knowledge to back up your position is value to you, and it's value to your client. So being aware of rules, regulations, laws, disclosures. I had a friend of mine whose family, both her parents passed away within a year, sadly. And, they're selling the property to the neighbor. A friend of one of the brothers was like, "Yeah, I can sell it for you." We have all heard this. And just sort of put the deal together. But there were tons of things that were missed in that transaction. So for example, one of the brothers was still living in the property, so they could avoid some of the tax issues with Prop 19. And if you are not familiar with Prop 19, you wouldn't have known that there's like essentially a loophole if one of the family members is still living in the property. And so they're delayed on the tax bill to do. There's just a number of things that go along with transactions that, if you know your stuff, makes you the valuable person in that transaction. And it is, it's not something you can just, fake in the moment. It takes time. And so if you give a little bit back to your own business, this I would recommend be it. Knowledge. And I actually applaud all of you for being here because of that. It explains what the responsibilities of an avid are and when that is triggered. You don't have to do an avid. An avid is simply a detailed informational dump rather than the little one paragraph section on a TDS that includes the information you are aware of. It is really more, I know it seems like a pain that we have to fill out another form, but it's more for your protection than it is a pain. Because if you are, for example, having a conversation with a seller and they mention that they redid their pool 3 years ago, they didn't put it in their TDS. You can put it in yours because, again, if after the fact there's an issue and somebody comes back and says, I wasn't told about the problems with the pool, and the seller says, well, I told my agent that we redid the pool and you didn't put it anywhere in your disclosures, then it becomes your problem. So you can, again, make sure that your information is all in the place that will help protect you. And again, in writing always is the best. And also, something you were told by the seller should be mentioned as the seller told me that, not the pool was redone. So, because if you say the pool was redone, that's your statement. The seller told me the pool was redone is a recitation of something that the seller told you, and that's not your disclosure. Affidavit and non-foreign status. A lot of people get confused on that and what that means and why it's done. National hazard disclosure reports. Okay, that's changing a lot. And it has to do more with fire than anything else. And that's another thing, actually, I'm going to go into here in a minute, is the fire requirements are specific to CAL FIRE. And there is a new regulation that's called zero lot line or zero line, zero. Well, I forget what they call it, but it's zero from the house out 5 feet. And the regulations for that have not actually been written yet, but they are in place, if that makes sense. This is our government at work. Thank you. So basically, from the house out 5 feet, you shouldn't have anything against your property that is flammable. And the problem, and I'll show you here in a minute, the problem with that is what is next to your house. So we're all aware of trees, etc. And we know that we can, trim trees and, clean out the gutters, stuff like that. Natural hazard disclosures, what that entails. So here's another one. Notice regarding gas and hazardous liquid transmission pipelines. In San Diego specifically, there are a number of areas that had buried pipes. A lot of people are not aware of that. And we actually had a transaction a number of years ago, and my company was sued for it because the seller was unaware and the agent didn't look closely at the title report. It did have a notation for an easement across the back of the property for SDG&E, gas and electric. And they didn't inquire what that was for, and it was for gas lines. And so these people had a gas line across the back of their property, and it was right about the time that big explosion happened in the Bay Area where, a city block basically blew up because a gas line ruptured. Then they discovered that they had a gas line in the backyard, didn't know. And so, of course, they sued. So again, it helps to understand what the information that you're looking at actually means. Megan's Law database disclosure, you are to point them in the direction. You don't do anything on that. Don't mention it except that it's there. You give it to them. Just a number of these which clarifies what they are and specifically what the requirement is with regard to the disclosure. And then these I love, the statutory and contractually required inapplicable cases. So this is the one that I mentioned, the ESD and WHS or WHSD, which are in when the seller is TDS exempt. And that one is a clear, Oops, wrong one, sorry. There, this is the fire one. So this is the zero line, and I just pulled up this one section, and I can give you the link to the, it's still proposed verbiage on this legal requirement. But the thing that gets me is, so from the house 5 feet out, this is that 5 foot range here. And you can't have things that could be wicks that are touching the property. So they give these two photos, and this struck me so much. So this house is, doesn't have any trees on it. It doesn't have anything touching the roof. Everything looks great. So this area here and the fence are what they consider to be fire hazards, and those need to be removed. So this is their example of those items removed. So you'll notice that it's been moved back from the deck area, which is wood, and then they put a metal gate that's touching the house instead of the wood one that was there before. So you'll see the wood, and then there's the metal one. But they also removed the railings, which I don't understand why they removed the railings, but maybe because this railing was touching the house. But I don't know, if they could make this one metal, why wouldn't they make this one metal? But that's just me. But this is their example of how this has been dealt with. Again, it doesn't go into well, technically it went into effect October of last year. But it doesn't become a requirement for 5 years for existing structures. It's immediate for new homes. But again, it's very difficult to require adherence to a regulation that has not yet been written. This is the temporary, or so far what they've got, regulation. And I think it'll probably be something pretty close to this, but I just find that to be intriguing. Because again, it has not even yet been written. This goes into effect for existing properties in 2030. So August, or I think it's October of 2030. So this is the page that I was telling you about that has all of this information on it. The sales disclosure checklist, the REO disclosure chart, the lease rental disclosure chart. So basically what this does, and this mentions new laws, the sales disclosure checklist. I think this one, the checklist and the chart are two extremely helpful. So this is the one that gives all of the information on what is required, where it's required, and it will give you context for if you want additional information. So you can look like you know what you're talking about when you talk to your client. So the Homeowner's Guide to Earthquake Safety booklet and questionnaire is it's a requirement if it was built before 1960. A lot of people add it anyway, just because we have earthquakes in the state of California, but it technically isn't required. It's part of the disclosure. We have earthquakes. There's the lead one. There's there's so many things in here. But again, when your client asks you a question, you want to be able to answer that question with some specificity, and this will help you do that essentially. Then the other one that's super helpful is the sales disclosure chart. And this is the one that gives you the information on all of the specific rules. So for example, flooding, that's big in Rancho Santa Fe, funny thing. We had a number of floods in that valley there when Lake Hodges overflowed, and all of that water went down through that valley where the ranches and stuff are. And those were in the floodplain. And so a lot of people are not aware that there are certain areas that are still considered floodplain in San Diego, which is not something we think of. We don't tend to think of excess water in this state. what the rules are with regard to carbon monoxide detector disclosures and where those are supposed to be, all of this stuff. Again, you can get lost in all of the information that you could potentially pull up. Fire home hardening. So again, this is the one that I was talking about. So the zero zone is, July, I said August. July 2025. So the existing homes will be July of 2030 because it's 5 years from implementation date, and this is the implementation date. Then you have material facts and what those are. We get this question a lot. What is a material fact? Then you have Megan's Law. We went over that a little bit. Private transfer fees, a lot of questions about that and what those are, and how that can be disclosed. So a lot of this information, again, is specific to the transaction that you're necessarily going through. May not be everybody. But again, when you're asked that question, or if you're working in an area where those are questions that come up, that's something that you're going to want to make sure you have available. Okay, so one of the issues, and we're going to go into in September, more detailed line by line. So the contract, the RPA, was just updated in June. But if you look here, there are some sections. For example, commissions, broker compensation are on the RPA, procuring cause guidelines, the BRBC, those are all under revision. And the reason those are under revision is because the legal lawsuit issues have not all magically gone away. They are still being tweaked and recognized, and they're being worked on with regard to keeping our legal protections in place. So those are still under revision, and they will be changed at that time. So there's also, and has become a question more so recently, the open listings or limited service brokers, like I'm only going to put on the MLS. And that form is also under revision. Again, specific to the federal lawsuit, and making sure that we're in compliance with that. So this is a really good section to go through when you have questions about any of these disclosures, and specific to when they were revised, how old. Some of these are, very old, like 2011 or 22. This is 22, November of 22. But there's some very much older ones in here. And so you want to make sure that you're up to date on the things that have changed recently, and what your responsibility is with regard to them. Again, you can look up the specific law that backs that up, and also you can just pull up the information from the county or the city or the state, and give that to your client. Okay, so buyer representation and broker compensation. The BRBC, right now, I don't think it's going to change a lot, but there are going to be some tweaks to it, specific probably to language. So you're going to have in your BRBC, your disclosure regarding agency relationship, pretty standard. You want to make sure you have all of your information, and your DRE number and everything is in there. And when you go through this broker representation or buyer representation form, you want to make sure that you fill out the information properly. So representation period, that's from when you had them sign it. Date prepared, it shouldn't be after that, sorry, should be, yeah. From when you had them sign it until whatever that timeline is that they've agreed to work with you. If it's more than 90 days, this is automatically not in effect. It is automatically it just disappears, basically. So we've had some turned in that were, for 6 months, and it's just basically a piece of paper at that point. So you want to make sure you stay within that 90-day period, whether it's exclusive or non-exclusive. And here's another one that's kind of interesting. Property type, single family residential is the standard. And if you want to exclude that, you can check this box. If you want to add which I think is a little bit, I don't know, doesn't really follow super cleanly. But if you want to be single family and multifamily, you want to check this box. And industrial and vacant land and commercial, et cetera, you check these boxes. If you want to exclude, you check this box. It's a little bit sideways, but there you go. Make sure you put counties or cities that you're working in. My daughter lives in Indiana, and she sent me the one that her realtor figure sent to her, and it said the southern half of the state. Probably not enforceable if it's too big an area, by the way. It has to be something that you can effectively service and you are knowledgeable in. So it's extremely difficult to be knowledgeable in half of the entire state. So you want to make sure that your area is a manageable area. If they want to look in another area at a different time and you're familiar with that other area, then you can go and fill one out for that other area. Don't try and be like the entire state of California. Probably not going to stand up if it gets challenged. The other thing is, this is, again, not a form that you're just filling out to cause more paperwork. Buyer preferences and priorities is a very helpful form. So this form basically, well, you will fill out this part here that's in blue. This part that's in salmon pink is filled out by the buyer. So they're going to tell you, here's my price range, and I want this as my primary residence, second home, income producing, personal use for, like, my niece, nephew, mom, dad, other, whatever. And I want a single family home or whatever they specifically want. They're going to tell you what that is. They're going to tell you what areas they want to really hone in on. And any other things. I've got to have a pool. I don't want a pool. I got to have a view. Whatever those things are that they want, then you can focus on those areas. You can always change this, or they can always change this as you move on. But what this does is, when you get to the timeline of this transaction, and you have purchased, for example, or they have purchased a home that they said was going to be their primary residence, and it was not their primary residence, you have in writing that they told you that that's what it was. You weren't part of a scheme to defraud the government of taxes, or a lender of taxes. So again, we're a litigious society. We can get a little crazy with this, but I always say good fences make good neighbors. And the reason for that is because it's very clear what the responsibilities are of both sides. And it makes it much more clarification of the transaction when you get to it. I have no idea why they put this in again, but they do put in another disclosure regarding real estate agency relationships when you get to the transaction portion of this. And by the way, don't forget to mark that they're the buyer. This will remain blank if you don't fill it out. And then you get into, make sure you put the date, and date prepared is going to be the one that you refer to forever after. And that's kind of a funny thing, because it's not, so a contract becomes applicable, becomes in use when it's signed by both parties. And that last signature date is the date that it starts, right? So that's how you determine day 1, day 2, day 3. But every time you refer to this contract, you refer to this date here, the date it was prepared. Because all other subsequent, additions, contracts, counters, whatever you do in this contract will have different dates on it. This is the one that says consistent, and this is a reference to this transaction. So you want to make sure that you understand that and use this date, not the date it's signed. The other thing is, when we go into escrow on transactions, a lot of times people aren't filling out this information on the company and the agent that is the selling side. So we just write an offer and we only fill out our information. Technically, and again, if somebody is looking for a technicality on a tight market, if this isn't filled out, it's an incomplete contract. You don't want to give anybody any ammo to ever get out or sniggle out from under a transaction if your client got a really good deal and they want to they got another offer that was $200,000 higher. So you want to make sure that you have all of your I's dotted and your T's crossed. So in this one, I think I just pulled from a previous transaction. So it's 150 all cash, 30 days close, calendar dates after buyer signature or July 16th. No. Oh, expiration of offer. So we only gave them 1 day to answer. And then the down payment amount. So they're going to put 25,000 down, and then obviously they're not going to get a loan. And then they're going to do increased deposit. So they're going to do an increased deposit. So one of the things that's really interesting on this form, and I think that they're looking to change, is this increased deposit isn't shown in these numbers, right? So it just shows your balance of down payment is 2125, and that's the amount that they're going to put down before close. Because that timeline isn't a date certain, the additional deposit, increased deposit addendum, will show that they're going to put an additional 40,000 down to make up to 3% essentially of the purchase price. And that will be placed into escrow upon all contingency removals. So unless you add this form in here, this now does not become, this does become, but if you don't put it in, it does not become part of liquidated damages. So the liquidated damages law actually states that the liquidated damages is up to 3%, no more than 3% of the purchase price, or the actual deposit, whichever is less, right? So if you have a $300,000 down payment, they are only responsible up to 3% of that purchase price as potential damages in a lawsuit should they lose. So it limits their liability. But it also specifically states that unless you specify that that additional deposit is liquidated damages, it's not. So again, you want to make sure that you pay attention to little details, like we're putting more money in, especially if you're the listing agent. If that money does not come with an additional increased deposit addendum, then it's not part of liquidated damages. And should those people walk for whatever reason, that money is not in question. It just it can be released. We all know nothing is automatic. But again, you want to just have as many positives in your column as possible. So this buyer is writing an all cash offer and they're going to show that they have the money and they don't have a loan. So they're not going to have an appraisal. Yes, they are still going to have an appraisal. And so what they've written in is that they will accept any appraisal that's within $50,000 of that price. A lot of people don't understand what this appraisal contingency specific to the appraisal gap means. If you put $50,000 in there and the price comes in, so we have a offer price of 2,150. As long as the appraisal comes in at 2,1 or more, that seller is willing to accept that, even if there's a $50,000 gap between what they paid and what that appraisal says. If you have a loan for the purchase of this property and you have an appraisal gap, more than likely your buyer is going to have to come up with that difference in cash. So that's a very different kettle of fish, as it were. We saw a lot of that during the 2020 crazies where, when our monkeys could get deals, and a lot of properties were being written with no contingencies, no appraisals, no nothing. And of course, if you had a loan, you had to still get an appraisal, even though it wasn't a contingency. And if you mark this little box over here that says no appraisal contingency, then you are going to be responsible for no matter what that appraisal comes back at. In this case, he says, I want an appraisal contingency, but I'm willing to eat up to 50,000. If it's more than 50,000 under what I paid, then I'm not going to buy the house. That's what that means. So then you have informational access to the property. A lot of people leave this the same, and I've seen this become a problem because once they've removed contingencies, that's generally when people want to go in and start measuring for drapes and furniture and whatnot. And unless you have this understood, it's not as a contingency. You're not going to be able to back out for something after you've removed all contingencies. What this allows the buyer to do is show their parents, measure for drapes. I forgot how many refrigerators there were outside, that kind of stuff. It's informational only. I see a lot more of that with the kind of the bigger houses where people want to do, room by room assessments, that kind of stuff. Get your decorator in there, get a painter in there for bids, that kind of thing. Insurance, all of these are standard 17 days. Review of seller documents, preliminary title report. That's another one where you have an option or ability to really kind of step in and help both your seller and your buyer, again, with disclosure. So on this particular one, I think is written, I wrote it down here. Yeah. So the title company, I think I made up a name, the perfect title company. So I wrote in here that the perfect title company to provide plotted easements in the title report. Again, that situation with the gas pipeline, I've had situations where there was a very vague reference to an easement on a title report. And when you asked for plotted easements, it showed it going right through the yard where the guy wanted to put a pool. So there's a lot of situations where most of the time it's going to be nothing, but sometimes it's something. And so you want to avoid that something and have that information available so that the company is giving you the information that your buyer or seller can utilize to their benefit, essentially. Oh, seller occupation. That's another one that has become a problem. When you have that the seller occupancy is, or sorry, buyer occupancy is upon recordation of deed, that can be any time. It's a very fluid timeline. You could have a special recordation and the thing closes at 8 a.m. And then technically they're supposed to have possession right then and there. That's an extremely difficult thing to do. So you may want to have a conversation with your buyer and or seller before you get into this part of the contract and have that clarified before it's written so that you know, in this case, it's written to give them 2 days from the close of escrow. So you close escrow and then they have 2 days to vacate the property. They can move all their stuff out. I believe this one is written with they have asked for it to be cleaned. Yeah, professionally cleaned, including rugs within 24 hours of seller departure. And also they want to have this that's another one, the chimney inspected and cleaned by a professional chimney sweep. We've had that situation happen where close escrow in the summertime and in the wintertime, they go to light a cheery fire to have their s'mores and the living room fills up with smoke. A lot of people don't clean their chimneys. They don't have chimney sweeps. It's kind of a quaint little idea, but the usage is very important. So again, just pay attention to little things and be of value to your clients. But this gives them 2 days after the close of escrow. They get to move their stuff out. Your buyer has asked for them to clean the property. It gives them time to do that. So again, have that discussion, talk it over with your clients, and be of value to both of them. I think it removes some of the stress on the seller that, the minute that thing closes, and we have to wait for it to close to be able to move, but then we have to move the minute it closes. A lot of that is problematic, especially for larger homes. So again, work through it with them. Make sure you have a clear understanding. Make sure you have it in writing, what those responsibilities are. And have that understood in advance of that issue becoming an issue. On this one, make sure you check all of the things that are important to your client. The one that kills me is the bathroom mirrors. This one is automatically checked. And I was laughing, and I the first time I saw that when they redid this the first time, and I asked Brian up in CAR. I'm like, is that a problem? He goes, yeah, you'd be surprised how many times people take the mirrors out of the bathrooms. I was like, okay, that's the one that's automatically checked. None of the other ones are. So make sure you ask that question. Do they have an electric car? Do they want the electric car charger? Potted trees and shrubs, you'd be shocked at how many times there's fights over potted trees and shrubs. Oh, that pot belonged to my great aunt, Edna. Okay. So again, clarification in advance, fences, neighbors, that whole thing. You want to make sure that if they want something, it's here. The raised bed. Oh, that's another one. Somebody stole all the raised garden beds from the house. Outdoor cooking area and gazebo. It was one of those ones that was movable, so they moved it. So make sure you have those all included if it's important to your guy. And you can exclude things like a dilapidated storage building, the grandma's chandelier in the entry that's too fussy, that kind of stuff. Make sure you put it in the contract if it's important that you either get it or don't want it. It's not an automatic, I thought you'd take all your stuff. Sometimes no. They're supposed to leave it clean, but again, if there's no expectation, for example, that the storage building was going to go, then they would leave a dilapidated storage building. Natural hazard zone disclosures, we're all familiar with that. Wildfire reports, that one is an issue, but it's kind of almost a whole nother day. Other than the zero line that, has yet to be determined, but understanding that that's coming. And it does sort of make sense in a way. Everybody has all of the wood chips, in their gardens right up next to their house. So literally you're giving the fire kindling up to your house. It sort of doesn't make sense. And I get it. Some of it's a little bit, I don't know, capricious in my book, but whatevs. Escrow fees, each to pay their own fees. We used to always have to write that in. Glad that's already there. Title company, home warranty provider, and make sure you include what is included on here. So what I would suggest to my agents, but you can do it at your own decision level, is to get a quote from the home warranty company, because you can have in here a cost not to exceed. If you have a quote, you know what that number is. And so you can make sure that you put that in there, and you can also include all of the things that are important to your client. Most people, first time they ever do a house with a guest house, that's 2 home warranty plans. That's not one with 2 build, unless they're attached. So 2 home warranties are for a house and a guest house. You want to make sure that if you've got a large property that you include that. A lot of this is automatically filled out. Agency relationships, buyer investigation, advisory, etc., wire fraud. Blah, blah, blah. All of this stuff is pretty self-explanatory. And then the increased deposit addendum, as I mentioned, goes into effect when that addition is put in there. Then you have that 2 days that I mentioned. So this is an addendum to the purchase agreement. Oh, that's another one that I came into recently. People don't understand the difference between addendum and modification. And so you're adding something to a contract, or you are modifying the existing contract. So if you're changing price, for example, that's modification. An addendum is something in addition to the contract as written. So just to be aware, and questions ask your brokers, but basically this is always going to be an addendum. So you're going to give them 2 days from the close of escrow to vacate the property. They're going to give them 2 calendar days. And if you're not aware, the day 1, so today is day 0, tomorrow is day 1, the following day is day 2, for purposes of counting contractually. The delivery of possession fee is $10,000 to be held at escrow and then given back to the seller when they vacate the property. And that's to cover basically, and you can use whatever number you want, but that's to cover if they, gouge holes in the wall as they're leaving, they murder all the plants, all the things that can happen in 2 days. Then again, have the conversation, clarify what this is for, explain the situation, why this is being done this way. This money is held in escrow, it's held for 2 days. and you're giving it back to them if the condition of the property is the same as what you expected, and the property was cleaned, and all of those things were done. So that covers really a multitude of sins. If they didn't clean the property, if they left it a mess, if they didn't remove that building, if they, whatever they did, that property, I mean, that $10,000 can cover a lot of that issue. Okay. So does anybody have any questions while we're here? Okay, good. It looks like we do not have questions. Now, understand that in September, we're going to go a lot more in depth with the changes, the RPA, the specific issues, and the contracts that are attached to the RPA. So if you want to sign up for that one, that will be again, September class, and we will be thrilled to have you back. And oh gosh, 10 minutes to spare. I said I was going to talk fast, but I must have gone really fast. Okay, cool. All right, you guys, thank you very much. I appreciate you. Appreciate taking the time. Get out there and stay cool on this crazy hot day, and stay out of trouble.